uh, closing argument of Mr. Eyman. Mr. Sanders appearing on behalf of Mr. Eyman. Good morning, Mr. Sanders.
Good morning, Your Honor. Can you hear me okay?
I can, thank you.
Your Honor, I would like to start where I left off, discussing the court's non-monetary relief order of September 13th, 2019. Then I'll talk about some of the constitutional issues which not only underlie this whole case, but shape the statute and help us to understand the provisions of the statute. I'll talk about some of the specific points raised by Mr. Newman in his argument, and finally discuss the state's proposed penalties and injunctive relief. I appreciate the court providing time for extended argument here, but when I finish, I'm sure there'll be many topics that I have not addressed. So I'll try to keep that in mind, Your Honor, that this is not intended to talk about everything in the world. The court's September 13th, 2019 order for non-monetary relief stated Mr. Eyman failed to report $766,000 in campaign donations that he had a duty to report because he is a, quote, continuing political committee, close quote. This order denied Mr. Eyman the opportunity for a fair trial, or any trial for that matter, on this issue. It was in the nature of a default judgment. The court entered partial summary judgment based on its September 13th order. Based upon this order, the state now wants to fine Mr. Eyman over $1 million and subject him to reporting requirements as a continuing political committee for the rest of his life. I have addressed this topic before, to Your Honor. However, important new facts were disclosed in the trial. First, there was no specific prejudice shown to justify the order, just exactly the opposite. And secondly, the state seeks to extend the order beyond its scope to include even child support payments paid after the order was entered. To justify such an order, a case law provides there must be the presence of three different elements. First, there must be a willful and deliberate refusal to obey a discovery order. Second, the party's actions must substantially prejudice the opponent's ability to prepare for trial. And third, the trial court explicitly considered a lesser sanction. I'd like to focus my comments on the second criteria, that is, the party's actions substantially prejudiced the opponent's ability to prepare for trial. Substantial prejudice is always required to justify such an order. It is never presumed. There are a number of cases that stand for this proposition, among them Burnett versus Spokane Ambulance, 131 Washington 2nd, 484, Marina Condominium versus Stratford, 161 Wash App, 249, and Rivers versus State Conference of Mason Contractors, 145 Washington 2nd, 674. These cases and other authority required a detailed record of the facts of prejudice and detailed findings so that there can be appellate review if necessary. In this case, the record to justify the order for non-monetary relief was the Perkins Declaration of September 5, 2019. He called it his first declaration, and the Attorney General motion of the same date. Near the end of my last oral argument, the court stated on the record that it took the matter very seriously and spent a great deal of time on it. The court stated, and I quote, "The court got the moving papers far in advance," close quote, of the hearing. So I would take it to be obvious the court not only had the declaration of Perkins and the motion of the Attorney General, but it studied them and it relied upon them. If my assumption is wrong, please, I invite the court to correct my misunderstanding. Here, the prejudice alleged was Mr. Eyman withholding the identity of donors based upon the Perkins Declaration of September 2019. The state's brief in support of the order on page 14 claims, and I quote, "These contributions go by the very heart of the state's case. Without the names of the donors, the state cannot ask them for the purpose of the donations." The claim was, of course, that Mr. Eyman was withholding the names of the donors. The declaration of Mr. Perkins at paragraph 32 states, and I quote, "The best example of how the Eyman defendants' long-standing misconduct in discovery has impaired the state's ability to prepare for this trial is their concealment of donor identities." Concealment of donor identities. This is the showing of prejudice which served as the basis for the court's order. However, at the trial, Mr. Perkins admitted that he had to cancel checks for all donors included in the $766,000 for a year prior to September 13th, 2019. He had the names, addresses, amounts, dates, phone numbers, etc. of each and every donor. I believe the court had the right to rely on his declaration under penalties of perjury and did rely on that declaration to accurately state the facts. However, now we know the declaration and motion were false. Names of the donors were not withheld from the state. It had them all. Every canceled check, name, address, phone number, amount, and date. Mr. Newman began his argument talking about how my client had been fibbing for the last 20 years. But I'm not talking about fibs. I'm talking about perjury. And it appears that the Attorney General, Robert Ferguson, suborned that perjury. The declaration of Perkins is on his pleading paper. He is an employee of the Attorney General, and he made this declaration on behalf of the Attorney General. So we're asking the court to do two things. One, find the truth. Factually find that the statement is false and misleading. And secondly, deny the state the benefit of this order obtained through its own misconduct. We ask the court to vacate the September 13th order and give us a fair trial on the merits. If the court didn't know this was a lie before, it knows it now. Also recall our motion to reconsider the order of September 13th, 2019 was denied summarily by the court. But attached to that motion for reconsideration was an authorization for every single one of Mr. Eyman's bank accounts, the same ones that they already had and more, and that Mr. Perkins used those authorizations to construct Exhibit 352, claiming that Mr. Eyman had another $71,000 in unreported donations that the state wants to fine him for. It is a lie that the state didn't know his donors, and now this court knows the facts. And I believe that it is also a fact that we spent 7 or 8 months supplementing interrogatories, but 100% of the state's case presented at trial had nothing to do with those supplements. As of September 2019, the state's discovery was virtually complete. Now I'd like to address some constitutional principles that should be recognized by the court in the construction of this statute and should ultimately govern the disposition of this case. Our trial brief and our response to the state's motion for partial summary judgment sets forth the constitutional concerns predicated on the First Amendment. We encourage this court to read and study as many of these constitutional cases as it can. Not only will this enlighten the court on the relevant constitutional principles, but it will demonstrate how this statute was carefully and narrowly drafted to avoid constitutional problems when it is properly applied. But the state urges the court to apply the statute in a way it has never been applied before, and contrary to its express language, rendering it unconstitutional if it is applied as the state proposes. The act is subject to strict or exacting scrutiny, according to Buckley versus Vallejo, 424 U.S. at 77 and 78. The only legitimate purpose of the Fair Campaign Practices Act in the context of ballot measures is voter education. That is, specifically disclosure of direct campaign contributions and direct electoral campaign expenditures. Buckley makes the distinction between direct campaign financing and issue advocacy. Issue advocacy and advocacy of a political result cannot be constitutionally regulated because it is core political speech. If the statute does not unambiguously limit itself to direct campaign finance reporting, it is unconstitutionally broad and unconstitutionally vague. Although properly read, it is limited to direct campaign contributions and expenditures, and that's how it should be applied. Buckley held that the statute can only be constitutionally applied, and I quote, to reach only funds used for communications that expressly advocate the election or defeat of a clearly defined candidate. This reading is directed precisely to that spending which is unambiguously related to the campaign of a particular federal candidate, close quote. Of course, here we're talking about a ballot measure, but the principle is the same. If the Fair Campaign Practices Act can be applied as argued, Mr. Eyman's fundraising for personal expenses, it is unconstitutionally vague and overbroad. It regulates core political speech, which cannot be constitutionally accomplished. Buckley emphasizes, and I quote, compelled disclosure in itself can seriously infringe on privacy of association and belief guaranteed by the First Amendment, close quote. The importance of private association was also the holding of NAACP versus Alabama. The right to anonymously associate and pool money is constitutionally protected. Here, the U.S. Supreme Court set aside hundreds of thousands of dollars in fines for refusal for the NAACP to disclose its members and contributors. Tim Eyman was held in contempt and fined for doing much the same thing. When the identity of the interveners was disclosed to the state, it threatened them with hundreds of thousands of dollars in attorney fees. Anonymity is important to the First Amendment. Reporting requirements are subject to strict scrutiny, and I'm looking at Utter versus BIAW, 182 Washington 2nd, 398. The only constitutionally sufficient interest is the substantial interest to disclose electoral campaign contributions and electoral campaign expenditures. There is no constitutionally sufficient interest to justify forced reporting of the finances of an officer of a ballot committee. And the statute on its face does not require that, although the state would. Recall, personal financial reporting is required of candidates pursuant to section, 235, who are required to file an F1 form, but not officers of a political ballot committee. The public has no interest in their finances. Probably the reason is that candidates continue in office and are subject to corruption, whereas officers of a ballot committee are merely sponsoring the measure. Once the measure is enacted, they have no further involvement with its enforcement and no discretion with respect to its enforcement. Aside from all that, even if Mr. Eyman were properly under the statute required to report, it is unconstitutional to subject him to unconstitutionally onerous reporting requirements. I'm looking at FEC versus MCFL 479 US 238. Mr. Eyman, as a continuing political committee, would be required to report every financial transaction for the last 8 years, thousands of them, and of course, all of them into the future. Moreover, he could not use his own money for personal expenses, that's barred by the statute, and would be required to hire a treasurer. He wouldn't be able to make any decision about how to spend this money. In short, he could not live without abandoning his political activism, which is the state's motive, not respecting the rights and following the law and protecting the rights of this citizen. That the state wants the court to misapply the statute is apparent from its oral argument. For example, Mr. Newman argued at 1 hour 25 minutes into his argument, quote, "If you are getting paid to allow you to do advocacy work, you have to report it," close quote. Absolutely not. That is core political speech, not an electoral campaign contribution. The statute doesn't require it be reported, and the Constitution provides Mr. Eyman a First Amendment right not to report it. And it provides the right of free association and anonymity to the donor as well. Now to reply, Your Honor, to some of the state's more specific points in its argument. Much of what I have said today and on January 7th pertains to and is a refutation of what the state stated in its oral argument. However, I will present some specific rebuttal on some specific facts. The state starts by talking about DataBar and claims that DataBar refunded money directly to Mr. Eyman and it was improperly reported. However, DataBar is never mentioned in the state's amended complaint. It is not their claims are itemized in their amended complaint. DataBar is not one of them, and it is not properly before the court. Moreover, the record shows that the transaction was reported by the campaign treasurer, not Mr. Eyman. Nevertheless, Mr. Eyman tried to amend the report, but the PDC would not permit him to do so because he was not the treasurer. This illustrates the very first point in our argument, and that is that Mr. Eyman not only has no reporting responsibility under the statute, but he cannot report anything under the statute. The state spends quite a bit of time discussing matters that are outside the statute of limitations. Recall the statute includes March 2012, but nothing before it. But a lot of the state's arguments focus right there, prior to 2012. For example, the state tries to prove a 2012 kickback by citing a 2010 email suggesting a 50% signature gathering price bump in an earlier campaign, which never materialized. It never happened. The state mentions various gifts received by Mr. Eyman prior to 2012. But during that period, that is not only outside the statute of limitations, but people have a right to give Mr. Eyman anything they want. And unless it is an electoral campaign contribution, it need not be reported by anyone, not even a campaign committee. The state claims that Initiative 1185 produced a kickback to Mr. Eyman, but there is no proof of that. All campaign payments to Citizen Solutions were reported and properly so, every one of them. Apparently, the state argues they shouldn't have been reported as payments to Citizen Solutions, but rather as payments to Tim Eyman. I guess this is a novel, a bizarre approach to the case. It is not something that any rational campaign treasurer would even consider when reporting payments to Citizen Solutions for signature gathering. And I might add that this was not a phony or fake. $320,000 of the 320,000 signatures were actually gathered by Signature Solutions, and had they not been, the measure would not have qualified for the ballot. So the state claims that $308,000 of payments to Citizen Solutions were not to Citizen Solutions, but to Mr. Eyman. But we know that every penny listed paid to Citizen Solution was paid to Citizen Solutions. And we know that Citizen Solutions can do anything it wants with its money, and it need not be reported. The state goes outside the statute of limitations to talk about $270,000 payment requested by Mr. Eyman. This was never paid. The consulting agreement ultimately entered into in July of 2012 with the Citizens Solutions was not $270,000, but $308,000. There is no connection between the two figures. The state does not deny that Citizens Solutions was paid fair market value for the signatures it collected, however, tries to construct an argument it was paid too much. It compares gross amount paid to Citizens Solutions with the net amount paid to individuals on the street collecting signatures, but it fails to make the distinction or the disclosure that Citizens Solutions hired sub-vendors who in turn made a profit and then hired individuals on the street. So when we say an individual on the street was paid $1 or $1.50, that is not what Citizens Solution had to pay the sub-vendor or coordinator to obtain those signatures. But in any case, money paid by Citizens Solutions is not reportable by Citizens Solutions or by the campaign. If the Attorney General or the court thinks that that would be a nice provision, the argument should be addressed to the legislature, but we have to follow the statute as written. The state faults Mr. Eyman for raising money from potential donors, claiming he had more money than he was letting on. This, however, does not violate the Act. The Act only requires disclosure of campaign contributions and campaign expenditures. They were reported by the treasurer. There is no personal financial disclosure requirement for a ballot measure officer, only a candidate. A candidate fills out an F1 form pursuant to Section 235 of the statute. This is a big distinction in the Fair Campaign Practices Act between how they treat candidates and how they treat ballot measures. The state claims that Stan Long was a ministerial treasurer. However, the state has prosecuted ministerial treasurers such as Barbara Smith for improper reporting. Moreover, if Stan Long is a ministerial treasurer, that doesn't mean Tim Eyman has any reporting requirements whatsoever. They're just not in the statute. He is not a treasurer, ministerial or otherwise. The state claims that the consideration for the consulting contract of July 2012 in the amount of $308,000 was not for future work. However, all testimony from the parties is to the contrary. But even if it was an outright gift, that doesn't mean payments from Citizen Solutions to Mr. Eyman or Watchdog were campaign contributions. The Citizen Solutions was paid by the campaign for signatures, and obviously they got them. 320,000 of them were turned in. Citizen Solutions made a profit and can do anything it wants with its profit. There are no reporting requirements. There's no regulation on how much of a profit they make. There is no bailout if they don't make any profit. This is a free enterprise system, at least to this date. Period. The committee paid Citizen Solutions a final installment on July 6th to secure the delivery of these signatures. They paid Citizen Solutions what Citizen Solution was owed. After that, the money was Citizen Solutions, and they could do what they wanted. The state claims that Mr. Eyman made a concealed loan to citizens in charge so it could make an in-kind contribution to the 517 campaign. It claims this is concealment contrary to Section 435, but that statute does not apply to loans. A donor need not disclose, a donor, that is citizens in charge, in-kind donor, need not disclose the source of his money or the maker of the loan. A campaign committee does not disclose the source of a loan to a contributor. This is the way the statute is written. That's how it's worked. That's how it's always been applied. The state claims a loan, by definition, is a contribution. Remember, they were talking about the contribution definition. They say the very first word is loan. However, you have to read more than the first word. Their claim is false. A loan for full consideration is not a contribution. That's in section 005, subpart 15, subpart A, subpart single I. This loan was 100% repayable. If there was a default in part on repayment, it is still a loan. A loan is a loan. The state claims the loan was paid back by, quote, other contributors to the 517 campaign, close quote. Not so. The loan was paid back by citizens in charge. Mr. Eyman asked his friends and supporters to donate to citizens in charge, hoping that they would get citizens in charge more money, which it could use to repay the loan. Repayments to Watchdog from citizens in charge had nothing to do with 517. 517 did not repay the loan, nor did donations to citizens in charge from Eyman, nor did donations to citizens in charge from Eyman's friends. The state claims that Mr. Eyman received concealed payments for political work, close quote. The state says checks labeled legal defense counted as political campaign donations if not deposited in Eyman's legal defense fund. However, the state takes the position that legal defense funds are not reportable at all. State Exhibit 352 recounts $71,000. The state says this is for, quote, political work, close quote. The statute doesn't require reporting donations for political work, only for an electoral campaign, and that is specifically contributions to and expenditures by an electoral campaign on the campaign. This approach by the state violates the First Amendment, and it is also outside the scope of the statute. Mr. Newman, in his argument, said, and I quote, I believe I've quoted this before, quote, if you are getting paid to allow you to do advocacy work, you have to report it, close quote. No, you don't. This is core political speech protected by the First Amendment. Mr. Newman goes on to another section of his argument, which he entitles Reporting Violations. The state wants the court to find Mr. Eyman a, quote, continuing political committee, not as a discovery sanction, but as a matter of fact. But note that the state rarely says continuing, close quote, when it talks about a political committee, because the state knows that Mr. Eyman cannot be characterized as a continuing political committee under the definition in the statute. And no individual anywhere ever has ever been so characterized. The statute requires an expectation of contributions to a campaign. There were none, as well as a organization which receives those contributions, which is part of the definition of continuing political committee, and is plainly not met by a single individual. However, we agree that the September 13th order should be vacated, but there is no basis to conclude on the merits Mr. Eyman's is a continuing political committee. He is not a ballot measure, and he is not an organization. He doesn't seek or spend money for campaigns. End of the story, period, full stop. Mr. Newman states, and I quote, what matters is he has expectation of receiving contributions to further electoral goals, close quote. However, that is not the statutory or the constitutional standard. Furthering electoral goals is very much like the problematic language discussed in Buckley that unconstitutionally swept in protected issue advocacy and was disapproved by the High Court. The state can't live with the statute as the statute is written. The court has to be particularly careful to read the words of the statute and understand the difference between what the statute actually says and what the state's argument is. The state says, and I quote, fighting for taxpayers is a political goal. close quote. That's at 1 hour and 30 minutes into the argument. However, fighting for political goals is not a subject of this statute, and it would be unconstitutional if it said that. There's a lot of people that fight for political goals. That doesn't mean that they have to report everything that they do in their life to the Public Disclosure Commission. Mr. Newman also used an interesting example from Eastern Washington, where Mr. Eyman apparently appeared at an outdoor meeting, and a friend of his passed the hat. And Mr. Eyman characterized what he said as, quote, "This collection is for Tim for all he's done for us over the years," close quote. This is not an election campaign contribution. It is not reportable. It is the essence of protected speech, and this illustrates the unconstitutional approach of the whole subject by the state. The state defends its position, saying that this illustrates the, quote, "expectation of receiving contributions," close quote. Sure, but not for an electoral campaign. Only that qualifies, not just a contribution for any purpose. There's another distinction the state fails to make about what the statute says. The state points out that there was a $308,000 consulting agreement, and that wants to fine Mr. Eyman that amount for entering into the consulting agreement. But that was Citizens Solutions paying its money to Eyman. It's not reportable. Then the state claims apparently campaigns should not have reported paying Citizens Solutions money for signatures. So how does that work? It did pay Citizens Solutions money for signatures, and the signatures were provided. Is the state saying that it should not have reported paying Citizens Solutions for signatures, but it should have just reported paying $308,000 to Mr. Eyman? That doesn't make any sense. It's counterintuitive. It's not in accordance with the facts of the case. If the money was for Tim and reported as such, that means Citizens Solutions would not even get the original contracted $1,050,000, since the bumps only accounted for $160,000, not $308,000. The state's theory doesn't make sense. Moreover, if Citizens Solutions wants to give Mr. Eyman $308,000 for any reason, that's its right, and it's not reportable. The state wants to fine Mr. Eyman $182,000 for its loan to Citizens in Charge, or I should say the watchdog loan to Citizens in Charge, claiming it was really loaned to 517. But those are not the facts proven in this record. It wasn't loaned to 517, and there was no duty on Watchdog to report this, nor a duty on 517 to report it either, nor a duty of Citizens in Charge to report the receipt of a loan. We know the loan wasn't to the campaign. We have the canceled checks to Citizens in Charge. All of this is a fantasy made up by the state in its convoluted approach to the case. The state wants to fine Mr. Eyman $832,000 for gifts from his friends as living expenses. This claim is unprecedented. It's bizarre. It is not supported by any precedent in this state or any other state ever. That is a continuing political committee issue, which I have previously discussed. The state wants to fine Mr. Eyman $1,250,000 for not reporting monthly as a continuing political committee. As previously discussed, he is not a continuing political committee and has no responsibility to report as a continuing political committee. The state wants to fine Mr. Eyman $23,000 for the data bar refund due to an alleged reporting error. But Mr. Eyman is not the treasurer. It is not in the amended complaint, and he can't amend, and he cannot amend previous filings by the treasurer, although he tried. In total, the state wants to fine Mr. Eyman $2.6 million and then treble it. This is an outrageous sum, truly out of proportion to any like case under the PDC. Then Mr. Newman says Mr. Eyman is a very wealthy person who lives in a $1 million house on the golf course, and that people have a right to know how much he is making and his net worth. Well, let's start with what I call a fib. That's the word Mr. Newman used over and over again regarding Mr. Eyman, and it got on the front page of the Seattle Times, fibbing. Mr. Newman knows Mr. Eyman does not live in a $1 million house on the golf course. Mr. Eyman rents a condo in Bellevue, and his rent payments are listed in Exhibit 352. The house in Snohomish County is not where Mr. Eyman has lived since the state broke up his marriage. That's Karen's and the kids' house. Mr. Eyman's finances are well known now to the state. It gets monthly reports from the bankruptcy court. Mr. Eyman has about $40,000 in the bank, and from that must pay the state $10,000 every month to avoid default, as well as other listed creditors in the bankruptcy petition. When Mr. Eyman was on the stand, I attempted to go into some of his personal finances. The state objected, and the court sustained the objection. Mr. Eyman's financial shape is in reality untenable, and Mr. Newman knows it. As to the claim that the public has a right to know about Mr. Eyman's personal finances, there isn't any. There isn't any right to know that. Mr. Eyman is an officer of a political committee. He is not a candidate. Unlike a candidate, he need not provide any personal financial disclosure according to Section 235. He need not file an F-1 form. For the reasons I outlined last time, personal financial disclosure is not required from a ballot committee officer because the public has no legitimate interest in that information. But the state doesn't agree with the statute and wants to say it is something it isn't. I suggest that the remedy for the state is the legislature, not this court. A further word about penalties. The penalties urged by the state are maximum penalties. The statute sets no minimum penalties. We don't think any penalties are appropriate at all as a matter of law. However, if the court were to consider penalties, it should also consider Section 750, Subpart D, Subpart XIII, which directs the court to consider penalties in factually similar cases. The penalties argued by the state are grossly disproportionate to those in similar cases. We got into this earlier with respect to exhibits, and it was my understanding at that time that if the court were to find liability, we would take this up separately. However, I will give you two examples of similar cases. These two examples are relevant because they involve individuals, not massive corporations, and they involve dishonesty. The fines in these cases are a fraction of what is being sought in this case. There was no injunctive relief to speak of imposed in these cases, in contrast to the AG's announcement that he would like to wage something like World War III against my client. First example, the Aaron Reardon case. Mr. Reardon was the former Snohomish County executive and was fined $4,200 by the PDC for several reasons, including the use of county resources to campaign and raise money, the use of taxpayer-funded staff on county time and compute to harass officials he designated as his enemies. The case was investigated 3.5 years by the PDC. The PDC chairwoman, Katrina Assay, told the Everett Herald, and I quote, I feel like this is one of the most egregious cases I've seen. Like I said, there was a $4,200 fine, no equitable relief. Another case, which I think is analogous, is Moxie Media, because it involves roughly the same amount of money as our case, that is $300,000. This case involved a successful false flag campaign to deceive voters into rejecting an incumbent candidate. The campaign intentionally concealed the source of its contributions to make it appear it was from one side when it was in fact from another. The deception caused the defeat of an incumbent. The fine was $110,000 with no ongoing limitations on political activity, despite lying about sources of their financing to successfully influence an election and deceive voters, who were in fact deceived. The only equitable relief granted by the court was mandatory training. Lastly, the state argues for injunctive relief. Before we discuss this, I think the court should recognize that characterizing Mr. Eyman as a continuing political committee is something different from injunctive relief. This injunctive relief, the state wants to add on top of that. If he were characterized as a continuing political committee, he would have, through his treasurer, he'd have to hire a treasurer. He couldn't do it himself. He would have to hire a treasurer who would report all income to the political committee and all expenditures by the political committee. There are no exceptions. There's no exception for a W-2 or whatever. Everything that goes into the committee and everything that goes out of the committee has to be reported. And none of that can be used for personal expenses. That's also in the statute. In fact, it's part of the government's claim regarding the receipt of the $308,000. So characterizing him as a continuing political committee creates an impossible situation for Mr. Eyman. He simply couldn't live. But now they want to add on top of that an injunction. This injunction would put Mr. Eyman under this court's supervision for the rest of his life, unless he abandons all political advocacy, which is obviously his First Amendment right to participate in. The state seeks to enjoin him from, quote, directly or indirectly as to why someone should donate to a campaign committee or how the contributions would be spent. This is as broad as it is vague. Any promotional speech on the part of Mr. Eyman would be subject to sanction and would be chilled. He cannot do business, according to the injunction, with any vendor, quote, directly or indirectly, who provides or might provide services to an associated political committee. These are all free speech activities that the state would like the court to enjoin Mr. Eyman from participating in. The state wants an injunction saying that he must report all income of whatever nature or source unless from a W-2 employer. So I guess that the state's position is Mr. Eyman cannot seek self-employment without reporting all aspects of that self-employment. The state says that he should be permanently enjoined from, quote, managing, controlling, negotiating, or directing financial transactions of any kind for any committee, close quote. So I guess he can't negotiate a printing contract or a signature gathering contract or change phone numbers or do anything. It's in a straitjacket. You cannot participate in a free society with those kind of restrictions. The list goes on and it goes on, and I will not attempt to summarize all of it. There's just too much there. Such an injunction would eliminate his free speech activities and eliminate his ability to meaningfully participate in any ballot measure campaign, which is exactly what the Attorney General wants. This is in combination with reporting every financial transaction associated with characterizing him as a living, breathing, continuing political committee, and it leaves him no room to breathe to participate in a free and democratic society. And I believe that we see references to no room to breathe in cases like NCAA or NAACP versus Alabama. That freedom means that you have to have freedom to breathe when you're exercising your free speech rights. Here, there is none. So, in summary, the case is designed to eliminate Mr. Eyman as an advocate for less taxes, smaller government, and a free society. It will put him in virtual jail with this court as the jailer, with unending court hearings in the future to supervise every aspect of Mr. Eyman's life. In conclusion, our statute simply does not support the state's claims. As a reporting statute to guide men and women of common understanding, it must be applied in that way as well. This is a statute which exists in the heart of the First Amendment political advocacy and must be applied as clearly written in a common sense way. It is not a statute which deals with original and bizarre theories, but rather simple reporting. That is anything but the state's case. It requires campaign reporting of election contribution and election expenditures. That's it, only it. Only the treasurer has the reporting responsibility. Mr. Eyman is not a treasurer, and he need not and could not report anything. Stan Long reported everything he was required to report. The state's claim regarding 2012 reporting is meritless. So to the proposition that Mr. Eyman is or could be a, quote, continuing political committee cannot be squared with the requirement that contributions be solicited only for actual election campaigns, not individuals active in the political process, which is what Mr. Eyman is. This is not a case which tests whether the court agrees on every point or every action with Mr. Eyman, but rather if he has clearly violated the law as written. He didn't. The state's claim should be dismissed with prejudice, and Mr. Eyman should be awarded his reasonable attorney fees pursuant to Section 780. Thank you very much, Your Honor.
Thank you, Mr. Sanders.